Lucinda, and poor Lucinda's going to have a microphone. We're testing out a new way of doing our company meetings. You have a microphone, and I wish it had a stand. We're going to need to get a stand for it.
I can hold it.
Yes, I do want to say that Lucinda and I go way, way back. She is, if you don't know, she's a closer and runs this operation here, but she's also an attorney. An estate attorney, just took my stepfather's estate through probate.
Sure did.
And I trust her with everything related to anything legal. So thank you so much for doing this for us.
Happy to do it.
I sent her questions, so we'll let her work through that, but then we can open it up to Q&A, and I'll be watching online, so you guys can put it in chat if you have questions as well.
And I'm going to preface that with, this is March 19th, 2024. Things change. So if you're watching the video after that date, it may or may not still be true, because all of this has to do with the Texas Estates Code, and it changes. It changes every 2 years. So with that being said, I don't mind if you report it. So Carlin sent me some questions, but I think before I start with the questions, I kind of need to explain the outlay of probate. How many of y'all have had a closing where you've had like a deceased person, or Faith's raising her hand back there? You probably all had something that touched estate and probate. So in Texas, you can either die with a will, which everyone should, or you can die without a will. And in the title world, when someone dies without a will, we can do a number of things, but it's real important for y'all to let your escrow officer know immediately that you've got a deceased person. A question you should ask when you find that out is, hey, did they have a will? And if they didn't have a will, you need to let your title person know immediately, because it opens up a whole new way to do things. There are 2 ways to get that taken care of. If it's a blended family, and Donna, if you want to hand these out, and you know what, before I get started too much, Hollis Dean is here, and y'all know Donna. Hollis is a marketer as well, and I just want to make sure you know them. That's Faith and Kim in the back. They're escrow officers and assistants. But Donna, if you want to hand these out. So this is a handy dandy, and Carlin, I've got a lot of them that I'll send back with you. This is a handy dandy little thing that Judge Herman puts on his website. And if you're not a lawyer, you can almost practice law on Judge Herman's website. And I shouldn't have said that since it's recorded, but
We'll scratch that part.
yeah, but this is a really good handout for y'all. So if someone dies without a will, and it is a blended family, it shows you the scenarios of how an affidavit of heirship would take care of that. An affidavit of heirship is something that title companies, I'm going to give the rest of them to Carlin. You can give one to Hollis too. Here you go. And Kim and Faith might want one. This is a real good handout. So affidavits of heirship are non-judicial. That means they don't go before a court. That means the title company allows you to get your client, we work with the client, and they can fill out an affidavit with their family history. It works a lot of times. It works best when the family is not a blended family, when the mom and dad are the parents of all the kids. When mom and dad aren't the parents of all the kids, as you can see from this list, it goes to the kids, not the surviving spouse. So it's a number of things. Hi, come on in. We're just talking about estate stuff and when someone dies without a will. Sometimes it gets complicated. And one of Carlin's questions was, what happens if people refuse to go by this? It happens. It happens a lot. So I had one where mom and dad were married. They each, had kids outside that marriage. So when mom died, dad thought he got her half of the community estate, but he didn't. The kids got it. And her kids didn't get along with stepdad. And they didn't want to sell the house. And so it ended up in court, and they had to do a partition. So it gets really complicated sometimes. Sometimes it's real easy. But the bottom line is, if they die without a will, you need to let your title officer know right away. Do y'all have questions about that? Have y'all had that happen where you've had an affidavit of heirship and a closing? Was it smooth? You are? So is it mom and dad? Dad?
It's mom died and all the siblings trying to.
Yeah, because what happens with that in the closing, they all have to sign off on the deed. So if someone doesn't agree on the sales price, it's a big conflict, and they usually have to enter into a settlement agreement between the family, and that could take a month to work out. So you can see the timeline gets real important with that. When someone dies with a will, it's pretty easy. You just file the will for probate, and whoever the executor is does an application through an attorney with the court, has to post for 10 days. After that 10 days, you petition the court for a hearing. You can usually, from start to finish, what do we do your dad's in about 4 weeks, 5 weeks? Hayes County's a little quicker, not to slam Travis County, they're just a bigger county. They have a good system over there though. But when someone dies with a will, you just go by the will, and the executor can usually sign the deed. Sometimes in the will, it doesn't have what's called a power of sale, but that's something that, once it gets started, the attorney can notify the heirs of that, because if that happens, then you sometimes have to get court approval to do the sale, or you have to get all the beneficiaries to sign it. I see some, am I going too fast?
Yeah, so to clarify though, if there is a will and it goes to probate, they can still show up at court and dispute.
Yeah. Yeah, they can contest it. And then that enters into a whole different world of weird, because then if you have a contest, you start litigating, and that can take months and months. Usually though, most Texas attorneys put a clause in their will that says if any beneficiary contests this will, they get nothing. So it causes that to kind of stop. But the only two ways you can really contest a will is two ways. The person has to be mentally incapacitated at the time that they signed the will, or they have to be under duress. Somebody's holding a gun to their head. There's a lot of family undue influence. Maybe a daughter has convinced mom to leave everything to her, and she's living with mom and has unduly influenced her. So there's two ways to contest a will. If you can't prove either of those, and the contestant has to prove one of those, they'll throw it out. But it still takes time. You still have to get a hearing. Again, super important to just make sure if you've got a decedent that you notify everyone, and you can call me. I think Donna gave you all my card. You can always call me with questions. I don't mind answering them.
I'll just say she said one of her filings that another title company said, I'm not closing it. We have like 16 airships and
Yeah. Yeah, but you work through them, and that does happen where, can I lay this down? Let's see if it's over. Yeah, you can have layers of affidavits of heirship. I think we've had several like that, Carmen, where mom's dead, dad is dead, so you have to do an affidavit of heirship on both of them, but then 2 of their kids are gone and they have grandkids over here, and so it's just a huge family tree, and you just kind of go down through it. On those affidavits of heirship that title companies can take, 2 disinterested people have to sign that knew the family for at least 10 years. There's also a judicial determination of heirship. When it gets really complicated, you can go before the court, and the judge actually does that. And in that situation, it gets even more complicated because he makes it a dependent administration, which means you have to get the sale approved through the court. So as you can see, there's layers of this. I mean, there's no simple answer for me to sit here and tell you this is going to happen or that's going to happen, because there are so many different scenarios that I've seen in the years that I've done this, not just as an attorney, but as an escrow officer. And usually you can work through it. I mean, I don't know I've ever had any that have fallen through because of it. But I mean, you have to get to a point where all the heirs either have to sign it. Oh gosh, I'll hold this back up.
We're gonna stay.
I was just saying that there's different layers to this. So there's no easy way to explain how an estate works. Every single one is unique. The simplest ones are the ones with wills, which is why everybody in this room needs a will, especially if you've got real estate and kids. And you should encourage your clients to do that too. Carlin asked me a question, what happens if they had a will, but they didn't probate it in time? You have 4 years from the date of death to probate a will. If that doesn't happen, a lot of times in Hayes County anyway, you can get it admitted as a muniment of title, which means you get the will admitted. There's no executor named, but it gets recorded in the real property records and it passes title that way to the heirs named in the will. That's a muniment of title. That's after 4 years. But judges don't have to do that because you only have 4 years per the estates code to probate a will. In Travis County, same thing, a little bit harder to get it through. you usually just have to go back to that whole determination of heirship or a judicial determination of heirship. And then you've got a dependent administration through the court. But it can be done. But if you've got a person that, and you go to a listing agreement and they say, yeah, mom had a will, but she died 10 years ago, that will's probably not going to get probated. If it was 5 years ago, you can probably get it in, but anything past that, I don't think either court would ever enter that. Let's see what else. What else you have?
More questions from online?
Yep.
Okay, so Harvey has asked, he has a client, dad died, he didn't know dad had owned some land.
Uh-huh.
Now he knows about the land, what does he do with it? How does he get it in his name, or? does
So
buy
dad died.
something?
Are there other kids?
Let's assume not.
Okay. That's where you do the determination of heirship. You don't have to close, you don't have to do a closing to do a determination of heirship. An affidavit of heirship. So he would need to call me and would do an affidavit of heirship. That affidavit of heirship gets recorded in the real property records, and that acts as a placeholder. It's not, you're not ever going to have a deed that give from dad to him because dad's gone. But you would have that affidavit of heirship, and the county records pick that up. Title companies pick that up as long as it's done correctly. I've seen a lot of affidavits of heirship that people try to do on their own. They pull it off the internet again, and not everybody on the internet knows what they're doing again. And so the forms are sometimes not what a title company will accept, and they have to end up doing it again. So it's always good to reach out to an attorney and get the proper form that title companies will allow, because
Title company will ensure that.
yep, the title company, if it's done correctly, it will just be, it shows that the chain of title goes to the son or the daughter and son or whomever is also in there. All right, does that help?
So one is in jail and two are living. Okay. So.
That's okay.
So if I ask you a question, you're going to repeat the question again.
Oh, okay, okay.
So just say she asked Harvey's question.
She asked Harvey's question in the chat, and that was the answer to it. Yeah. Do you have any other questions in the chat?
Not really. Okay.
Carlin asked me about trust. Trust can be done while a person's still alive. And when you have a trust, they'll also have a will. And the will is going to say that everything I own at the time of my death goes to my trust. Usually, if an attorney's done it correctly, the trust is already loaded with all the real property. You've probably seen that in your closings where a trustee is signing over, the deed and everything. That's because that property was put into the trust. If it's not, the will's going to take care of it because it's going to say everything I own goes into the trust. Unfortunately, if they don't load it right, you've still got a probate, but the trustee is the one that would sign all your documents. That would be who you would do. On your contracts, when you have an estate and you don't have an executor appointed yet, you still need to write in there the estate of and let that executor sign. Because until you probate a will, the executor isn't the executor, even though the will says it is. A will has to be probated and they have to take an oath. You have a question?
Can you break down the process of the trust? So you mentioned that the trust is in the will, but it has to be worded in the will.
Yeah, so when I do a trust for someone, they come in and they want a trust, I'll do a trust, but I also do a pour over will. So in the will, it says that if I didn't name something, if I didn't load my trust properly, anything I owned goes into my trust so that the trust dictates. Does that make sense?
Yes.
Okay.
What are the advantages of the trust?
You avoid probate, but if you've got customers from California, Florida, New York, they're going to always think they have to have a trust because those states are really hard to probate in. Texas, a trust is going to cost about $5,000 and they're avoiding probate that costs maybe $1,500. So I don't see a lot of advantages in Texas unless you've got a 12, $25 million, huge estate, that you're trying to do some tax advantages, then a trust is absolutely necessary. But with a trust in Texas, because of the expense of it to set it up, because it's kind of cumbersome, a lot of times it's cheaper just to go through probate and have a will. But that's just my opinion.
So, yeah, I understood it. Trust is good to have, especially for your heirs, to avoid additional taxes like capital gains and things like that. So, but you're saying it typically has to, there's like a price point with that.
Right. Did I punch something, Carla? Is it still working? I'm not a CPA, so I'm not gonna address like capital gains and gift tax, but I will tell you this, Texas does not have a state tax. And the federal government, the threshold's real high. Unless you've got a huge estate, you're not going to pay any estate taxes. I believe, and you'd have to check on this with a CPA, because I am not a CPA, but it's my understanding that as long as you don't rent the property that you inherit and make money off of it, and as long as you sell it within 2 years, I don't think you pay capital gains, or you get that stepped up basis that they got. But again, I have no idea if that's
So I
right.
really checked with the CPA. I asked because one, someone's asked me about that, and then two, my current investor, he's purchasing properties for each of his kids.
Yeah, I have a lot of people that do that too. They need to consult with a CPA.
Okay.
That is really not, I don't do taxes, so
Okay.
I would have to defer that to a person who is more knowledgeable than I. Right.
And you don't want to be the provider of that position.
No, I know, it's just like, where can I guide them?
Yeah, there's good CPAs. Carlin could probably give you several names of some. I know I've gotten names from her, so I think that would be the route to take. We used to have one that we worked with here at Independence Title, but that was more for the other kinds of stuff. All right, Carlin, what else did you ask me? Let's see.
Anyone else in here have a question?
You said the minimum of 12, like around 12 million was when somebody would want to move toward the trust.
Probably somewhere around that or a little more, yeah.
But even if you have paid off real estate assets, you wouldn't necessarily say a trust or will be fine.
Yeah. Well, and there's a wonderful tool out right now, and y'all will probably see this as well. It's a transfer on death deed. Have y'all come in contact with any of those? So when you're alive, you can name a beneficiary to your real estate, just like you do on your bank accounts. And it's called a transfer on death deed. You keep it until you die. It springs into the name of the beneficiary that you name on the transfer on death deed. So you avoid probate on your real estate completely. You can avoid probate in Texas easily. If you will put, on your bank accounts and your investment accounts, if you name beneficiaries on those, that doesn't touch your estate. That's separate from a will, separate from the estate. And you can now do that with your real property with transfer on death deeds. And if you come across that, the thing you have to do with those is those have to be recorded during the lifetime of the grantor. So the person transferring and setting up the beneficiaries, that has to be recorded in the real property records while they're still alive. If you wait and record it after they're dead, it's void. But that's a good tool.
Yeah.
Yeah.
That in place of a will or?
Well, I don't think there's ever a reason to not have a will, because you never know. What if that deed failed, or what if they didn't record it, or, there's so many variables. I think you always need a will, but I'm an estate attorney, so I'm always going to tell you that.
Sure.
And there's more assets than just property, right? So,
Yeah.
Right, just give you all assets.
Yeah.
Right, and that's what you're saying, the bank accounts.
Yeah, you
The-
can.
The transfer on that transfers the bank.
No,
accounts.
the bank accounts, you can go to the bank, used to, in my old world, you would go and you would get the signature card, and on the back you sign it. I'm sure there's some online version now.
The bank stuff, because I've been going through this with my mom, is a nightmare. Like, it's really bad.
They don't help.
They do not make it easy at all.
Yeah. Now, Carlin's mom went through probate, so she's got authority from the court to act on her stepdad's behalf, and it's still hard.
It is still, we still don't have docs to get on the USAA, we won't even talk to her. We had an account that we didn't even know about. She got an email and said, here's your statement, and she flipped out, and she had never heard of this account, had no idea we had an account. And so she wrote to them and said, my husband's died, please tell me everything. And they notified the beneficiary of the account, which is not her, turned out to be his son. And so now we're waiting on documents from you, and I can remember what the letters and test.
Letters testamentory, I've got them, I'll hand them to you today.
Letters and
Mhm.
we need those to go access the,
Well, and you're running into, can they hear me? Could they hear you?
probably.
So Carlin's mom is having trouble with the bank because there was a beneficiary named on a USAA account. And because the beneficiary is named, that's the owner. Yeah, because when you name a beneficiary, your will doesn't touch that. It passes outside the estate because you've named a beneficiary. So you want to make sure always that your beneficiary forms are filled out properly. Some people forget to do that or update them. Yeah. But to answer your question, at the bank, the way you get a beneficiary named on a bank account is you go to the bank and you sign a card naming a beneficiary.
And they have to sign too.
And they do have to sign too.
Get their social security
Yeah, so, but it's doable, absolutely. And then the transfer on death is just for real estate. It does not have anything to do with the bank account. Yeah, yeah, go ahead.
I have a client who, his father remarried and then passed away 2 years later. And they all grew up in this house. Then they sold the house. And they thought the house was completely theirs. He died without a will. So does that mean that she gets 1/3 of the house?
Okay, we're gonna have to let them hear this. Yeah, okay, so you have a client and who died?
Correct.
He died. Left a wife,
Left a wife of 2 years.
left a wife of 2 years. He has kids outside the marriage. And so they inherit his half.
Did she live in the house?
He died in 2003. And they have been letting her live in the house since then.
So the mom has lived in the house. Stepmom has lived in the house with stepdad, with their natural dad, biological dad,
Yes.
Well, for 2 years.
for 2 years,
He passed. She's been there ever since.
right?
And now she moved away. She moved back home with her kids, whatever.
Right.
And they're like, all right, let's build a house. And I'm like, okay, we've got to figure this out. Because I think it belongs to her.
It does not. His half, their dad's half of that community, because it's going to be considered, I would assume, community, because she's lived there for a long time. Dad's 1/2 community interest is going to go to his children. And so she's going to own half of it.
She owns-
Yeah, yeah.
That's.
Yeah. Yeah, and that goes to that whole affidavit of heirship that I was talking about, this form, this thing that I gave you, this form here.
Mhm.
If you look at it, it'll have everything on there, married with children, and it shows you how it's split up. So, but yeah, she's gonna have to sign. Yeah, Carlin's saying she has to sign and all the kids have to sign, and that is correct. Yeah, yeah. Yeah, you're right. What you got, Kim?
I'm gonna take all this into, just a question, isn't there something about who's been paying the taxes if it's been that long since 2003, or is that not?
So Kim's asking if stepmom would be reimbursed for some of the taxes, and that would probably be, some kind of settlement agreement so that they could figure out the difference in the cost. But from an inheritance standpoint, aside from who's paid for what, the kids own his 1/2 community interest. Yeah. Does that make sense? Mhm.
She moved out 2 years ago. Taxes.
Oh, wow. So there's back taxes owed. Yeah. Yeah, you need to watch the foreclosure sale for sure. Did dad not have a will? Yeah. Well, he's been gone too long, 20-something years. You couldn't probate it anyway. Yeah. Does anybody else have any questions?
We have, going back to the bank account, Shannon's asking, what happens if there's no beneficiary in the bank account, where does the money go?
So the question is, what happens on the bank account if there's no beneficiary? The will would dictate. And if there is no will, then that affidavit of heirship would dictate. That's where they're going to run into a problem, though. A lot of banks won't take an affidavit of heirship that the title company will take. Many, many, many won't, even the smaller ones, and it forces them into probate. So you need to make sure on your bank accounts, you've got somebody named. I mean, if you're married, you've got a joint account probably, but if you're not, it forces, I've had to do probates for $5,000 in a bank account, I mean, it's just silly, but the banks won't work with you on any kind of affidavit of heirship that the title company. Usually those are just used for cars. You can transfer cars with them, and you can transfer real estate with them if they're done correctly. But bank accounts, the banks are not, they do not work well with that.
I learned,
Come here, come with me.
I learned cars that if like one spouse, the car's in one spouse's name and the other spouse didn't have it in their name, they have to pay taxes and registration to get it put into their name after the person dies. So that's something to think about. If you have paid off cars, get them put into both names.
Yeah, it's really good. If you're married, just get everything kind of jointly owned and you don't run into a lot of the problems. Mostly, if you have a will, you don't run into a lot of problems. I mean, that's just the truth. And if you've got elderly parents and they don't have wills, believe me, you want to encourage them to do that because it's going to be you that's having to straighten it all out.
We talk about wills, so the question online is, how do you file a will? We explain how will works.
So the question is, how do you file a will? Wills don't get filed until you die, and then they get recorded. The original does at the courthouse. Courthouse used to take them and put them in safekeeping. They've kind of gotten away from that because our counties have gotten so big. But usually you just keep your original somewhere safe. You make sure your executor knows where it is. When that person dies, you do an application to probate it. The original gets recorded at the county clerk's office or the probate clerk in Travis County, and it sits there. You never get it back.
You explain what it means to have.
Yeah. Okay. So never do a will on your own because 9 times out of 10, they're wrong. But if you choose to try to do one, first of all, Texas takes a holographic will. So if you don't have a will and you don't have the money to get one, I encourage you to sit down and write out the date, say, this is my last will and testament, and you go ahead and list everything you want to leave to whomever you want to leave it to. Sign it, make sure it's dated. Doesn't have to be witnessed, doesn't have to be notarized because we take a holographic will. That would be an admissible will into probate. It's messy, but we can get it done. That hearing takes a lot longer. You have to get witnesses that say that's your handwriting, you are of sound mind, all that kind of good stuff, but it can be done. If you don't go to a lawyer and you pull up Zoom or legal Zoom and all that, they're a mess. They are usually wrong. They will cost the person more to probate because they don't have all the Texas specific language in it. Because, you know, Texas, we've got specific stuff we like in our wills, and we're picky. And so judges are very picky, especially if you're in Travis County, because they're a statutory probate court, and they're gonna make sure everything's in there. Wills should say, this is my last will and testament. It's got your name in it. It's got where everything goes. It is witnessed by 2 people and notarized. I'll take that back. A valid will that's not handwritten is valid if it is signed and witnessed by 2 people. If it is notarized and has a self-proving affidavit, those 2 witnesses don't have to come to court. But it is valid without a notary, and it is valid without the self-proving affidavit. But on a good will, you'll have your self-proving affidavit that says, I watched this person sign, they're of age, they're 18 or older. My witnesses were 14 years or older. She appeared to be of sound mind, and we all signed in the presence of each other.
And can witnesses be recipients of the will?
So Carlin's asking if the witnesses can be recipients in the will. No, they cannot, because they're an interested party. So they could think, you know, mom could be sitting there, you know, completely incapacitated, but they want her to sign the will. So no, it needs to be disinterested, or at least somebody that's not a beneficiary to the will. But wills are very specific, and they're very broad. Some attorneys will put very specific things in there as to like a gun or a watch. A lot of wills now just say, I may leave a list attached to my will that leaves specific items to specific people so they don't have to get them redone over and over. I like those kind of wills. I like a will that will grow with you. If you have kids later, Texas, I mean, and you don't list a child that was born to you, it's still okay. The court's going to know that that child was born after the will was done, and they're still a beneficiary. You don't have to necessarily get it redone. It's a good idea to look at your wills about every 7 to 10 years. You are? Well, McKenna would still inherit. McKenna's still okay, even though you're missing her on your will, because she's considered a child. In the probate hearing, there would be a stipulation that she was born after the will was done. So she's still good. Tell McKenna she's still okay.
Question, what about mineral rights? Would you use a beneficiary or a transfer and death deed if there was no will?
You know, I honestly think you would have to talk to the person that's monitoring those. I mean, are they getting money for the mineral rights, or do they have, it's not producing, but there is a company, right? That's there. They will let you some of them have forms you can fill out that is like a beneficiary form. I don't know that they take a transfer on death deed, to be honest with you. I'd have to find out for you. I don't deal with a lot of mineral rights. I would assume they would. I would assume that would be something that they could do, but I would just call that company and ask them what their procedure is. They probably have their own specific type of form, and it probably has to be notarized.
And we reiterate that the will has to be the original.
Well, that's a good question. So Carlin's asking and I'm repeating for them, right?
Yep.
Can a copy of a will be admitted to probate, or does it have to be the original? We can get a copy admitted. If you can't find the original and you can prove that, okay, let me back up. If you have a copy of a will, the court is always going to assume that the person who wrote the will, who signed the will, tore it up. So you have to overcome that burden of proof that it's just lost. You just can't find it. She didn't do another will. That will wasn't revoked. But you can get a copy admitted to probate. Same kind of thing, a little bit harder. You have to get witnesses in there to say that it was their last will and testament. It's always a good idea if you can find the witnesses that actually witnessed the will, but if not, you can get some other people in there. But it's important to keep it safe and make sure your executor knows where it is.
With popularity of video, is that a
We don't,
bearing on anything?
we don't, in Texas, we don't take a videoed admission of a will or anything like that. We don't, you can't video yourself leaving someone something in Texas. Has to be written. Handwritten is fine, but not a video. They do that. The movies are always making you think of fun things, right? Texas is weird. It's a very good question. Yeah. Yeah. So she's asking about if you've got minor children, if you can put that in the will. Absolutely.
And then how do you, and my next question is, the guardianship for someone, whether it's asset. And you want them, like, you want them to help provide for your children, but there's additional, there should be additional assets, and you can, through a will, ensure that your children get those when they reach 18.
Okay, so she's asking about if you have a minor child or children and there's assets that you don't want them to get until they're adults or whatever age you choose. There's a thing in a will called a contingent trust. It's not a separate trust document, but it is a contingent trust. So when you have minor children, you name a trustee and you name a guardian in your will, and then you can also name a trustee for the contingent trust because a minor can't inherit. So if the minor inherits, it goes into the trust and your trustee manages that. So they're not buying a red Ferrari until they're, old enough to know better. A lot of my clients put 25 or 30 in that, the age 25 or 30. I think at 21, I don't know how I was at. Yes, exactly. Exactly. Yeah. But there's a contingent trust you can put in there. That's part of the will. It's not a separate trust. It's not a separate expense, or it shouldn't be.
Separate that to where you're providing expenses to the guardian to help care for the child.
Yeah.
And separate. Is that how people do it?
Yes.
Expenses that shouldn't be necessary.
So she's asking how the trustee would give to the guardian the money the kids might need. It says education, welfare. Your trustee would have the discretion to know what is needed. And you can put specific things in there. Absolutely. It's your will. You can make it any way you want to. Yeah. Yeah. You had a question?
Yeah, if a will says that, I leave all my assets to my two kids. Okay, when that person dies, can the executor of the will sell the assets?
Okay, so his question is, if it leaves it to two specific beneficiaries, does the executor have the power to sell it out from under them, pretty much? No, he does not. An executor has a fiduciary duty to do what the will says to do. And if he starts to do something different, they can petition the court to remove him or her.
That's a good topic though. You mentioned like if you have a closing and then because of the state, how do those proceeds?
Oh, yeah. So that is a very good question. So when you think they heard you, probably not. So Carlin is asking if the property is in the estate name and you have a closing, how does the money get distributed? It gets distributed to the estate of, so you have to open an estate account. But what you can do before that, the executor can always go ahead and do a deed to the beneficiaries. So if I die and I leave and my husband's my executor, I have two kids, but I left my real estate to my two kids, which I did. That means my executor can do a deed from the estate to them. So now they can put that money into their own accounts. There's a way around it. But if there's not, and the executor wants to sell it, the executor has to set up an estate account. You have to get an estate ID number, which is easy. You go to irs.gov, you follow the prompt for an employer ID number, you put in the information and it's right there on the screen. But the title company is going to require that. If it's in the estate name, the check that we distribute has to be to the estate. And then the executor takes that money out of that account and distributes it as the will states. But he always has to go by what the will says. Does that help? All right, Carlin, anything over there?
Question.
Yep.
What happens if someone has kids, they never were given the father's last name, and they were never added to a will, that cannot be contested by the kid.
Okay, so you've got biological children. They never took dad's name. No, they're not biological?
Yes.
Okay, okay, so they're biological children, never took dad's name, but they're his children. And the question was, there's no will. Okay. Well, if there's a will and he didn't leave anything to somebody, that's his prerogative. Yeah, yeah. If there wasn't a will, then they absolutely have a claim to their share. But if there was a will and he, if I don't like one of my kids and I decide they're not in my will, they don't get anything. So.
I have a situation right now. Husband, has early signs of dementia.
Mm-hmm.
Not there yet, but it's coming. The daughter's like, we have to sell.
Yeah.
What do we do with this?
So Carlin has a client who is still lucid, but has early signs of dementia, and they're ready to sell. So as long as he knows what he's signing when he signs it, he's lucid enough to sign it. Yeah, as long as early signs of, if he knows where he's at, the date, who's where and all that, then, he's perfectly fine to sign it. Yeah, it's only when they really don't know or they've been clinically diagnosed with later stages of Alzheimer's. Tracy had one of those recently where, there's just no workaround. Yeah, but does he have a power of attorney, Carlin?
Nobody has that yet.
Yeah.
So,
They need to do some estate planning real quick. Yeah, real quick.
I think
Yeah,
that
yeah.
Answered my question.
Yeah.
because I was gonna say, well, what if because it's early signs and then what if something triggers to where he's
Well,
okay, now fully diagnosed.
right. So a power of attorney would protect that. And that's something else I was going to tell y'all about. There, when you go see a lawyer to do a will, they're not just going to do a will. They're going to, well, if they shouldn't just do a will, they're going to do estate planning with anyone who comes in. They're going to, you should get a power of attorney, a durable power of attorney, a medical power of attorney. There's a thing called a living will. It's also called a directive. It's for lack of a better word, that document that allows your medical agent to, I'll say it nicely, withdraw care should you be hooked up to machines. It's, some people call it the pull the plug document. It's kind of crass, but you should get all those things because you're planning for you not being well. If you're not mentally capable of doing anything, then your medical agent's going to be able to make your medical decisions, and your agent under your power of attorney is going to be able to make any and all decisions for you financially. And that's kind of what they need to do. They need to do some estate planning. It's not just a will that you need the whole bundle of things because you never know what's going to happen. I could pull out here on this crazy road and, become mentally incapacitated, Yeah. Yeah.
I have a question. So, they one has a will,
Uh-huh.
but then they get divorced. Like, so a married couple does a will together and then they get divorced.
Okay.
What happens then?
She's asking a married couple does a will together. First of all, I would never do a will together. They're separate wills. But what if they get divorced? You need to do a new will. It's happened. And usually, I think Texas courts recognize that, they're divorced and it probably goes to the next, I haven't had one of those.
So it's just best to jump on that.
Absolutely. Yeah. And that's another one of those things where I said you should probably review your will every 7 to 10 years anyway. Yeah. You had a question?
I just feel like maybe I'm asking without client scenario, personal issues.
Oh, you can, it's fine. You can ask personal questions.
New property state, how does a married couple do separate wills? Like if you share everything.
So she's asking on since we're a community property state, why do we do separate wills? Because you don't own the whole. You own half. So your will's gonna say any any interest I own in real estate goes to, usually it's your spouse or your children or however, but you don't own the whole community. You only own half. You have a 50% community interest in everything. So you do your own will, because your will,
It all went to your spouse.
well, if you're married and if you are married and you don't have children outside the marriage and you don't have a will, refer to this, it does. It goes to your spouse. But you have to do an affidavit of heirship. It doesn't just go. Texas doesn't just say, oh yeah, it's yours. There has to be a chain of title to that, whether it's a recorded deed from a will or the affidavit of heirship recorded in the chain of title. Does that make sense? Did I answer that? Okay. Yeah.
On this question,
What? Yeah. Well, it addresses the property that the person owns.
Online question, how does one go about getting information from a will or past relative or find out if they have one?
So Carlin's online question is, how do you find a will? How do you find if a person had a will or get a copy of it? So if they okay, when a person dies, the will would be probated in the county in which they died. So you can start with the county where they died to see if it was probated. A county clerk or a probate clerk can tell you. They'll look up the name of the deceased, the person that died. So they'll be able to tell you and you can get a copy of it because it's public record. Otherwise, if it's not been recorded, you'd have to ask the people if there was a will. Yeah, I mean, the only time a will is recorded is if it's probated. You could check the real property records and see if an affidavit of heirship was done. That might tell them something.
So on that note, I guess how would you best advise someone, because also personal, I mean, my grandma passed away years ago, but she did have a will. One of my aunts was living with her, and apparently the will was never to be found. So is there any kind of like backup?
So your grandmother died and there was talk of a will, but a will was never found.
There was definitely known that there was a will.
There was a will somewhere, but they didn't find it. Okay, and your aunt lived with her.
Mhm.
So who got the house? So
They sold it.
so they went through probate or something and got an administrator appointed, or they did an affidavit of heirship. When a will is lost and no one finds it and they do a diligent search, it's assumed that it was revoked in Texas. But if they did an affidavit of heirship, I don't know how you would determine that. Unless you found it, I don't know how you would say that there was a will. Does that make sense?
Yeah. So just having a will and then just ensuring that you have an
Affidavit of heirship.
Okay, is that gonna help?
Well, you don't do the affidavit of heirship till someone dies. So you don't do that prior to death. That's in case they don't have a will, or if the will didn't get probated or, some other outside reason. But if you're asking me how you would prove there was a will, the only proof you could have is the will itself or a copy of it. Remember, because you can probate a copy. But if none of that was found, the estates code's going to say that it's assumed that it was revoked, burned, thrown away, that your grandmother, right? Your grandmother threw it away or revoked it. Yeah. Yeah, go ahead.
So for my parents right now, the way we're handling it, or they're handling it is the client's mom died, the will was probated.
So client's mom died, will was probated,
Seven
7 siblings. Okay, I'm going to stop you there. So she's dead, correct? So they want to name her as the executor because a power of attorney dies when a person dies. The power of attorney is no longer effective when someone dies. The will kicks in. So she had a will. So the executor in the will was named, and that's who they want to do everything. Okay, so no, ma'am, that's just the executor. A power of attorney has an agent, but a power of attorney that we sign during our lifetime, it's no longer valid once the person dies. That's when the will kicks in. So the power of attorney is gone. And now the will is what's effective. And they are probating, you said? So the executor will take an oath before the judge before they can sell the property. They have to do all that. And they'll be issued what's called letters testamentary.
they were sent, all the siblings were sent a, affidavit, airship to fill out, and that's what we're doing right now, so.
So the heirs are all filling out an affidavit of heirship, but there's a will, and the will was probated. Huh, that has me stumped, because if you've got a probated will and an executor, that executor has the power. That makes me wonder if the will doesn't have a power of sale in it, and maybe they're signing a waiver and not an affidavit of heirship.
They were all going to get the siblings to sign it.
Huh.
And they would do, you said our attorney, might have heard wrong, but.
I bet, I don't know, maybe a power of attorney, maybe all the heirs are signing something so that one person can sign on their behalf. So that makes me think the will didn't have a power of sale in it. And each one of each one of the heirs named in the will are going to have to, that the title company would require each one of the heirs to sign. But if they're all scattered about, they can all sign a power of attorney to name one person to sign on their behalf. That makes me think that's what's going on. Mm-hmm.
So that's back to the state account, how, so you're saying that he would have to open, or the money would have to go into the state account?
So she's asking about an estate account at closing to disperse everything. When the executor, but it sounds like to me, all of the heirs are having to sign on everything because there wasn't a power of sale. So, but yes, if they're paying it into the estate, he has to have an estate account, and then he will disperse to all the 7 or however many beneficiaries. The title company will not tell them how to do that. If the sale is netting 300,000, he's going to get a $300,000 check, and he's going to have to do the math and split that up between the heirs named in the will. Yeah, it'll be one check. Yeah, you're welcome.
And that's, I'll just add.
Here.
Like how this happens.
Because I'm not going to repeat all what you're about to say.
So that's where it's really important that the 7 are all on the same page as far as distribution goes. I had an issue where one of the siblings changed their mind in the middle of it, went to court, got, I don't know if it's an injunction to stop the sale. There you go. Did a list pendants to stop the sale because he didn't agree with the amount that it was being sold for.
Yep.
So that's why it's really important that everybody's all on the same page. And the minute anyone's rocking the boat, like we don't want to. And that's why it's so important. I want to stress to all the agents that we never want to go and list a property unless all this has been taken care of and title says go. Because otherwise, like I had one, it was a property in downtown Buda, and the vultures were out. Like they wanted it the minute he died. So I listed, I get it under contract, come to find out he had been married with kids prior. That wife never met those kids, had no idea. Yes. Like, so it can be a mess, like, and it can go sideways really fast, and it can take forever to get cleared up. So we just want to make sure all this is done before we ever put it in MLS for sale.
Yeah.
So the minute someone's disputing what's going on, they can go file that, and it like freezes.
It does. It's a list pendants. It's what it's called. Yeah. Carlin's right. I mean, when you go to these listing appointments, I know y'all are always so prepared, and you look it all up, and you've looked at the tax rolls. Don't trust those. They're wrong a lot of times. So it'll still list Mr. and Miss so-and-so, and you go to that listing agreement and you think that both of them are still alive, and they're not. Or it lists the husband's name, but the wife lived there, and you later find that out and she's dead. And so you got to ask all those questions, like, did your wife live here? Where's your wife? Which, it's kind of nosy questions, but you kind of discover a lot of stuff after the commitment comes in, because, and it's things y'all could ask beforehand. And on that topic, whenever y'all go to these listing agreements, I know, Carlin, this is off topic, but there's a whole lot of fraudsters, and these sellers aren't really the sellers. I mean, y'all are getting driver's license numbers or driver's pictures of it and doing all that, right? Yeah.
Not allowed to list property and land
Mhm.
without getting anything from you.
But Carlin, it's not just land anymore. Any absentee seller, we've had some sellers in Puerto Rico or different places. So any absentee seller, if they're not living there, you probably need to be treating it like it's vacant land. Yeah, I would. I mean, it's a scary world right now. Yeah. Yeah, we do TBDs. Yep, you just have to fill out a form for us and we'll absolutely do that. It's kind of nice to have before you go. You just have to bring it back to us. All right. Do you have any more good questions, Hollis Dean?
$13 million, 13.61 million is.
Oh, there you go. See, it went up from 12 million. Yeah.
13 million.
Yeah, yeah. Yeah, and Texas doesn't have state taxes, so we're good in Texas. But when you have sellers from California, Florida, New York, New Jersey, some of those, that they, you know, they're, they, yeah, 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 there are a lot of lawyers out there that want you to spend the $5,000, $6,000, $7,000 to set up a trust when in Texas you don't. You don't typically need a trust if you get everything else in line. I mean, and Carlin, take these back to the office and you can Xerox more. This is just a really good tool for y'all. If you look at it, and it just tells you exactly where everything goes. And it's got the little captions at the top. Married with children, married without children. It's kind of a good Bible. I use it all the time. And mhm. Her father passed away. Okay.
For 25 years.
Stepmom lived in the house with dad.
And so I would like to say half goes to stepmom,
Half goes to stepmom. Yep.
I would say yours.
Yeah. Yeah. His biological children.
Yeah.
Yeah. And if he didn't have any children, it'd be, this tells that too. It'd be his parents. If they're not alive, then it's his siblings. Or if his mom's alive, it goes to half to mom, half to the siblings. I mean, there's this little chart that you're going to take back to the office and give to all our online viewers. It'll tell her all that. Does that answer your question? Or did we not? Shanna, is that good?
I'm just wondering how I go about maybe getting that part of the estate, because she's kind of not being responsive to any of it, kind of ignoring all the facts. So I'm just kind of confused on how I would take the next step or action to get my share.
Okay. Well, Shanna, she has a life estate, so you can't kick her out of the community estate. So if they lived in a house together, you're probably going to have to wait to get your half when she's gone. Does that make sense? Because you can't kick her out.
Yes.
She has the right to live in the community property until she dies or moves out. And then whenever you start to sell that, or if she dies, that's when y'all would kick back and go through either a will or affidavit of heirship. Did your dad have a will?
He said he did, in his last weeks, but she says that she had no recollection of it and can't find one anywhere. So of course it's that kind of scenario.
Yeah. Well, that might work to y'all's benefit because the will might have said everything goes to her when he dies. So that means his half of everything goes to y'all, but the community estate doesn't pass to y'all until she's no longer living there. Does that
Okay.
help?
Yes, and if she's gonna decide to sell it,
Then that's when the title company is going to realize that he's gone and that is a blended family and that her kids are different than his kids. And that's when the affidavit of heirship kicks in and y'all will be named as heirs through
Okay.
that affidavit of heirship.
Okay, thank you.
You're welcome.
Hey, Carmen, I walked in, I think I was going to talk about that on your affidavit of heirship thing. Can you tell me that scenario, you never want them to get a bank account set up in the estate?
No,
No?
no. We were just saying that affidavits of heirship usually don't work for a bank account,
Okay.
only for real estate and cars.
So I guess my question is, Mike Stoss, again,
Uh-huh.
my question is, if we're using affidavits of heirship, the properties typically put into their individual names, correct?
Uh-huh.
So they wouldn't need a bank account for the estate, am I understanding that?
Oh, Carlin was just asking if it is paid into the estate, do we need an estate account?
Okay.
Yeah, not necessarily the affidavit of heirship thing.
Yeah.
Yeah. Yeah. No, it was an estate. Yeah, she was, yeah. I think that's what we were talking about. I think it was, we were talking about your mom's stuff. Don't leave without getting those letters. All right. Anything else, guys?
Thank you so much.
Oh, yeah, you're welcome. I hope I didn't confuse you more than I helped you. It is confusing, but you've got my card and y'all can call me anytime. Just make sure you.
Yeah, and everybody online, I'll post we'll scan it in and put it online so you guys can access it. And we've got copies of the Butte office. But thank you. Really appreciate it. Thank you guys for being online. Yep, no, it was great.
easy way to explain it, because it's kind of convoluted.
It sounds like it's like one thing after another, and it's like, is it truly